Ready, start. It was submitted that till date there is no order recalling or rescinding the disputed consent terms recorded in the original suit proceedings, and thus the complaint lacks foundation. Hence, the High Court was justified in entertaining the writ petition and granting a stay on further proceedings. It was further urged that the order dated 6th July 2023, whereby the complaint was referred to the DC, does not refer to even the barest of allegations set out in the complaint filed against the respondent advocate, and only a cryptic satisfaction has been recorded that the complainant has made out a case for invoking jurisdiction under Section 35 of the 1961 Act. When a regulatory body like the Bar Council intends to proceed for professional misconduct against an enrolled advocate, then it is essential that at least a bare minimum discussion of allegations set out in the complaint is made before referring the complaint to the DC. On these grounds, learned counsel representing the respondent advocate implored the court to quash the entire proceedings of the DC pending before the Bar Council and to dismiss the appeal. Heard the learned counsel on either side and perused the material available on record. As the present matter arises from an interim order under normal circumstances, rather than entertaining this special leave petition, we would have relegated the parties to pursue the pending writ petition before the High Court. However, upon going through the pleadings filed by the parties, and more particularly the stark and glaring facts set out in the counter affidavit filed by the respondent advocate, who was sought to be prosecuted before the BCMG, this court is persuaded to invoke its jurisdiction under Article 136 of the Constitution of India for quashing the proceedings of complaint as a whole. It is an admitted case of the parties that the respondent advocate never represented Nasli Randelia, Dara Sarkari, or Messrs. Olga Enterprises in the suit before the High Court. The respondent advocate had simply identified the plaintiff being the authorized representative of Messrs. Unique Construction in the consent terms, which stand undisturbed to date. By mere identification of the plaintiff, the respondent advocate cannot be held liable to face proceedings under Section 35 of the 1961 Act. Indisputably, the consent terms taken on record by the High Court continue to hold good and have not been recalled or rescinded. The role assigned to the respondent advocate was of identifying the plaintiff in these very consent terms. We are therefore of the firm opinion that no one can be allowed to raise an issue questioning the consent terms that were arrived at between the plaintiff and the defendants. Devji Parmar was not a party to the suit. Had there been any semblance of a right or claim of Devji Parmar in the suit property, Nasli Randelia would definitely have sought his impediment in the suit. Not only this, Nasli Randelia never projected that the so called firm Messrs. Volga Enterprises had any role to play in the dispute over the suit premises.